All right, well, it's a couple minutes after the hour, so why don't we get started with today's presentation. Thank you for joining us today. My name is Michael Waters. I'm a partner in BLG's Vancouver office, specializing in corporate finance. I'm one of the founders of BLG's Startup and Grow program, and I'm delighted to be moderating today's session. We hope you and your loved ones are keeping safe and healthy during this very difficult time, and we sincerely appreciate you taking some time to join us today. Today's presentation will focus on incorporation issues and key considerations for founders when incorporating a new business. This is the third session in our Startup and Grow newly minted webinar series. Before turning to today's presentation, I wanted to take just a few minutes to share some more information about BLG's Startup and Grow program. So what is Startup and Grow? Startup and Grow is a national BLG program. BLG is one of Canada's largest law firms with over 650 lawyers in each of Canada's major business centers, Vancouver, Calgary, Toronto, Montreal, and Ottawa. We are a full-service business law firm. We work with some of Canada's largest and most well-known businesses, as well as brand new businesses and everything in between. We appreciate that large law firms can be a bit intimidating, and the Startup and Grow program was designed in part to provide access to BLG's depth of expertise in a way that is tailored to meet the needs of entrepreneurs, startups, and early-stage businesses. So the Startup and Grow program provides a way to access a complete suite of legal solutions for early-stage businesses, including advice in the areas listed here. Today's discussion will be focused on corporate structuring, so we'll be talking quite a bit about that today. Some of the other areas I wanted to highlight in particular are the strength of our intellectual property group. BLG has one of the strongest intellectual property groups in the country, which when combined with one of the strongest full-service business law firms in the country, provides a unique combination for a Canadian law firm that provides a one-stop shop for top-tier expertise across all the practice areas critical to the success of an early-stage business. And as one of Canada's largest law firms, we have specialized expertise in emerging and growth areas such as autonomous vehicles, fintech, biomedical, healthcare, clean energy, industrial technology, and many others. So the depth of expertise across our platform, I think, is a real differentiator given BLG's expertise in the Canadian legal marketplace. We recognize that cash conservation and cost certainty are critically important to early-stage businesses, and we've designed the service offerings within the Startup and Grow program with this in mind. We have devoted significant internal resources to developing robust materials that we can offer on a fixed fee basis. And for brand new businesses, we also offer a Startup and Grow legal package, which incorporates BLG's best thinking across a range of key foundational documents, providing new businesses with a solid foundation for growth and for future fundraising from sophisticated investors. The key items included in our Startup and Grow legal package are set out here. I won't go through those in detail, but if you are thinking about incorporating a new business, we think this is a great resource, and certainly one that you would we suggest you consider, and we'd love to tell you a little bit more about. We have deep connections within the Canadian startup community. A few of our partnerships are listed here, and I know a few members from these organizations are with us today, so welcome. And as we are honored to have the chance to work with some fantastic entrepreneurs and new companies, a few of our clients are listed here. And again, a few of you are on the call today, and we welcome you. Okay, so on to today's agenda. As I mentioned, today we'll be focusing on incorporation matters and key considerations that founders should be looking at when considering whether or not to incorporate a new business and how to incorporate. So we'll talk with a very brief discussion about why you might want to incorporate in the first place. Then we'll talk about some jurisdictional issues. We'll talk about the pros and cons of incorporating provincially versus federally. We'll then go into sort of the nuts and bolts of the actual incorporation process to let you know how that works in each of the jurisdictions covered on this call. We'll then have a discussion of share classes, what share classes should you set up on incorporation, and some other considerations regarding your initial share capital. We'll then move to a discussion of founder shares. What should you, the founders, get when you set up your new business? And we'll discuss briefly the concept of founder share vesting. And we'll conclude with a very brief discussion of founder shareholders agreements. And I'll now introduce today's speakers. We've got a top-tier panel from across the country joining us today. We're joined by Danielle Luchek, who's a senior associate in our tax group based in Vancouver, does a lot of tax work as part of the Startup and Grow program. Welcome, Danielle. Jeffrey Taylor is an associate in our Securities and Capital Markets group based out of Alberta, one of the leaders of the Startup and Grow program out of the Calgary office. Delighted to have you here with us today, Jeffrey. Colin Cameron Vendrig, senior associate with the Securities and Capital Markets group at Toronto. Again, works with a number of startup and early stage companies based out of our Toronto office. And Fiona Lynn, an associate in our corporate commercial group based in Vancouver with great expertise working with private companies, including startups and early stage companies. So we've got a great panel today. So we'll kick things off, and before we get started, we'll just kick things off in terms of some discussions around business structure. I will say there is a Q&A chat function. So if you have, a few of you have submitted questions in advance in this presentation. We thank you for that, and we'll try to address some of your questions as we go today. If you have questions during the course of this presentation, by all means, feel free to type them into the Q&A function, and we'll try to address those at the end. We'll leave some time for questions. We'll try to leave 15 minutes or so at the end of the presentation for questions. So we'd encourage you to insert your questions into the chat function. Okay, so the first quick note is just on the right business structure. If it's just you, there's a couple ways you can do it. You can exist as a sole proprietor, which is unincorporated, which is what a lot of folks start out as. They're just running the business in their own personal capacity. And we'll talk briefly about why you might want to not do that. But that's very common for early stage businesses is to simply do business in their own personal capacity. If it's just you, the alternative is to incorporate, and we'll share some of the reasons why we think it's a good idea for you to incorporate. If there's two or more people involved in your business, you have a number of business structures available to you. We're not going to go into these in detail in today's presentation, but we just wanted to flag there are other structures you should consider if there's two or more of you starting a new business. Today we'll be focusing on incorporation and the reasons for that, but at the outset we just did want to flag that there are some additional business structures that you might want to consider depending on your unique circumstances. Tend to be tax driven. There tend to be tax reasons or your family holding company or other reasons driving some of these other structures. So corporation is by far the most common form of business organization, but something to consider and something we'd be delighted to talk to you about in a bit more detail. Okay, on to the next slide. And very quickly, just why should you consider incorporating in the first place? A few reasons are listed here. First of all, a corporation has a separate legal existence from you as an owner of the business. So it divides up the ownership and the legal entity. So once you incorporate, you are a shareholder of that business, and you exist as a shareholder and perhaps as a director, perhaps as an officer, but the corporation itself is a separate legal entity. That has a number of advantages. Immortality, which is good if you're raising money or your business partners or people are contracting with you. It's nice to know that the entity people are doing business with will continue on. Perhaps the most important is limited liability for shareholders. As a separate legal entity, a corporation is liable for the obligations and liabilities of the corporate entity, which separates out the liability for shareholders. So if you are operating as a sole proprietorship, you're just running your business without incorporation, and you're entering into contracts, and someone decides to sue you, all of your personal assets are on the table in terms of something that can be claimed. This is potentially disastrous for people running businesses as a sole proprietorship. So one of the most important reasons why we suggest people incorporate is to insulate yourself individually as a shareholder from the liability of the activities of the corporation. So now a corporation as a separate legal entity is able to engage in activities, is able to enter into contracts, and if there is a claim against the corporate entity, the assets of the corporation are at stake, and then only in exceptionally rare circumstances, very, very rare circumstances, will the assets of the shareholders be at risk. apart from their initial investment, which of course is at risk if the corporation were to go bankrupt. Some other reasons here: preferential tax treatment, which we'll turn to in just a minute. There's a bunch of important tax reasons why you want to incorporate, especially for a business in Canada, which we'll dive into in a bit more detail in just a moment. But transferability interest, if you want to sell a stake in your corporation, much easier if you incorporate. Ability to raise capital, much easier to raise funds as part of a corporate entity than just you operating as a sole proprietorship. Once you incorporate, you take advantage of shareholders' rights and remedies that are built in under corporate legislation, depending on the jurisdiction you work in. And you have the ability to enter into a shareholders agreement, which is a contractual agreement among the shareholders about how you're going to run the business itself. And we'll talk about that near the end of this presentation. So I've sort of covered off two of the most important reasons, which is that you would incorporate, which is developing an entity with a separate legal existence and sheltering yourself from personal liability. The other key reason is tax. And with that, it's over our heads to talk about, so we wanted to involve one of our tax lawyers to share some information about the tax advantages of incorporating. Over to you, Danielle.
Thanks, Mike. So there's a bunch of complicated terms on this slide, and I will take you through each of them. I thought it would be helpful to set out these terms because as you're doing your own research or reading, they do come up over and over again in the tax literature and online resources. So the first is that what we want to focus on here is what's called a Canadian controlled private corporation, or for short, a CCPC. This is very generally an entity where the more than 50% of the voting shares are held by Canadian residents. So if you live in Canada and you incorporated a company, then until you bring in some non-residents, your company would be a CCPC. And there are a number of tax advantages that apply directly to CCPCs because the idea is that the government wants to encourage Canadian entrepreneurship. So the first is that there's a small business tax rate, which is 9% federally up to $500,000 of income, and then there's a small provincial rate on top of that. That rate is much lower than your individual income tax rates if you're making income as a sole proprietor, where you're just paying your standard marginal tax rates, so which range from 50 to 30% federally and plus a whole variety of rates provincially. But the advantage here really only exists if you're making enough money to so that you don't have to distribute your corporate profits. The tax system is designed so that ideally there is, if you earn the money in the corporation, you distribute it to the shareholders, or just the individual earns the money, that the tax at the end of the day is the same. There's a little bit of leakage. The system isn't quite perfect, but if you were to earn income at you incorporate, you earn income at the small business rate, you think, oh, this is great, then you pay out dividends because you need that money to live on, well, then you're basically back at the same place. So we say that the advantage of the small business rate really only applies if you are earning enough income that you can leave some money in the corporation, and then you're only paying tax at the 9%, and you can keep that money in the business. The second benefit is that when you sell your business, you might have access to the lifetime capital gains exemption if your shares qualify as what we call qualified small business corporation shares. And if that's the case, then you can shelter about $850,000 of capital gain. Third benefit is that you can compensate your employees in a tax-efficient manner using employee stock options. So sort of at the beginning, Mike alluded to, startups don't always have significant cash flow, but you do want to still have, good people working for you. And so one way to do that is to give stock options to those employees, and you can only do that if you're incorporated. And then lastly is the availability of scientific research and experimental development tax credits, what we call sort of SR&ED for short, or sometimes people call it SR&ED, depending on who you're speaking with. And these are tax credits that are available. There's a big technical definitions about what counts as scientific research and experimental development, but lots of technological innovations that startups might be involved in will qualify under this program. And if you're a CCPC, you can actually get cash in hand for the money that you spend on SR&ED. So you can get tax credits of 35% of a spend of up to $3 million. And that tax credit is refundable. So that means that you can get cash in your pocket even if your company's not actually making money. There are SR&ED credits for sole proprietors, but they're just much smaller. It's basically a 6% credit as compared to 35. So there's big numbers, and there's money on the table there for you if you're engaged in SR&ED. And with that, those are sort of our high-level tax comments, and I'll hand it over to Jeff.
Okay. Over to the next slide, Christy.
So one of the first questions we often receive is, where should I incorporate? In Canada, you can incorporate under provincial legislation or federally under the Canada Business Corporations Act, or the CBCA for short. Your choice of where to incorporate will determine what corporate statute will govern your company. Historically, we've seen many startups incorporate federally, often because they think a federal company has a certain cachet to it. However, there have been some recent changes to the CBCA that might make incorporating federally less advantageous. For example, CBCA companies are now required to maintain a register of individuals who have significant control over the business. And there are also proposed amendments that would require companies to provide additional disclosure on a number of matters, including diversity and employee well-being, and to also provide shareholders with a non-binding say-on-pay vote. Complying with these new additional requirements can often be cumbersome and quite costly. And additionally, the new amendments codify and possibly expand the duties and obligations of directors. So overall, these factors usually result in us now recommending that companies incorporate provincially as opposed to federally under the CBCA. So when choosing what province to incorporate in, the general rule is to pick the province where the company principally operates. That being said, if your company has a number of directors who are not Canadian residents, or if your company has the potential to be particularly active in M&A or complete a number of corporate restructurings, you may want to consider incorporating in British Columbia as opposed to Alberta or Ontario, because the BC corporate statute has some additional flexibility regarding these matters. If any of these special circumstances apply to you, we encourage you to contact us, and we'd be happy to have a conversation about choosing the right incorporation jurisdiction that makes the most sense for your business. And with that, I'm going to pass it back to Mike, who's going to talk quickly about some business names.
Thanks, Jeff, and always nice to have an Alberta corporate lawyer say nice things about our BC corporate statute, so thank you for that. Well, the only other note I'll add on that is to consider if you're incorporating federally, one of the things you'll need to do is what's something called extra-provincially register. So you need to register to operate in a province if you plan on operating in a jurisdiction, which most businesses will be doing, which just costs a bit more money. It's a few $100s. It's not that much more, but it's just it tends to be a little more cost-effective to incorporate provincially as well too, which is one important consideration for early-stage businesses. Wanted to add a very quick note on business names. We encourage new business owners to consider seeking trademark protection for their business name off the bat. The other thing you might consider seeking trademark protection for is your logo. But logos tend to change over time. Your business name, though, if you think you'll be attracting goodwill, there's value in the name, and there's very limited protection associated with simply incorporating provincially or federally under your name. And people get a bit confused because you have to, and we'll talk a little bit about this, you need to search your name, you need to go to a registry, you need to make sure you're permitted to use the name you want to use, you then register your name, so people think there's some protection associated with that, and it's very limited. So one of the things we encourage new businesses to do on top of the incorporation process is to seek trademark protection for the name. We actually have, if you look on our Startup&Grow website, our second webinar, the last one, talks about IP matters, and there's a bit of a more detailed discussion about the benefits associated with seeking trademark protection. Not enormously costly. If you think sort of in the $1,500 to $2,000 range, that's kind of what you're looking at for an uncontested application. And the shameless plug, we include one trademark application in our Startup and Grow legal package because we think it is something that is important, is often overlooked. Okay, with that, I'll go to the next slide. And we'll turn it over. We'll now go into the sort of the nuts and bolts of how you actually incorporate your business. And as the outset, we say, we recommend this is not a do-it-yourself enterprise. We'd recommend talking to a law firm and one of us. We'd be delighted to help you out, and we have a bunch of good, great resources to help you do this. But we did want to walk you through the process, and for some people, they do want to do it themselves, and in some jurisdictions, there is the ability to do that. So we'll at least give you the information on how to do it yourself. Over to Fiona to talk about how to incorporate in BC.
Okay, thank you, Mike. So the companies incorporated in BC are incorporated under the British Columbia Business Corporations Act. Generally, there are 4 steps to incorporate a company in BC. First, you must decide the name of the corporation. In BC, there are 2 forms of corporate names. The first is a numbered company, which usually starts with the incorporation number, followed by BC Ltd. If you choose to use the incorporation number as the company's name, you don't need a name approved and reserved. But if you intend to use a specific name, that name must be approved and reserved by the registrar. So in order to get the business name approved, the name needs to follow some specific legal guidelines. For example, the name should have 3 components. The first is a distinctive element, followed by a descriptive element, and ending with the corporate designation. I wanted to highlight some restrictions of legal guidelines for corporation names. For example, the word government in a name is not acceptable. Other words that may imply a connection with government require the government's consent, such as the usage of words provincial, ministry, and agency. And these are some statutory restrictions. There are some other restrictions from the statutes. Those statutes restrict or prohibit some use of certain words, such as bank or banking, architect, trust, in corporate names. So choosing a business name is not actually straightforward as one may think. So we encourage you to consult with lawyers and other professionals before submitting a name, and we are happy to help with that. And after you submit the business name and the name got approved, you can reserve the name for 50, 60 days. And within the 56 days, you must complete the incorporation process. So the next step is to prepare the incorporation agreement and the articles of the company. So an incorporation agreement is a short agreement in which the incorporators agrees to take shares of the company. Then after incorporation, the incorporator will transfer the shares to shareholders if they are different persons. The incorporation agreement must be signed by each incorporator, and it is to be held in the company's records office. It does not need to be filed with the registrar. And the articles of the company set up the rules for the company's conduct. There are some provisions that are commonly included in the article. For example, provisions to restrict share transfer, to set a quorum for meetings, and to set a special majority required to pass a special resolution. Even though there is a standard form of article under the BC Act, in our experience, it does not fit each company. So you may consider the form to meet your company needs. And after you have prepared incorporation agreement and articles, you can incorporation application with the registrar online. The filing fee is $350 plus $30 for name reservation. And after filing, you will get original certificate of incorporation along with a certificate copy of incorporation application and articles. And these articles must be kept by the company as part of the company's records. Once the company is incorporated, it must be organized in order to carry on business. For example, the company will pass several resolutions to acknowledge the incorporation, to approve issue of a share certificate for taken by the incorporator, to confirm number of directors and to appoint the directors. As you can see, the incorporating a company is not as straightforward as one may think. And Mike has already mentioned, we do not encourage you to incorporate a company by yourself. But if you want to do so, you can find additional information on the registrar's website and do an online search incorporating a BC company. Now I'm going to hand it over to my colleague Jeff to talk about incorporating a company in Alberta.
Great. Thanks, Fiona. So incorporating in Alberta follows a very, very similar process to incorporating in BC. So I'm going to focus mainly on the differences between the two jurisdictions. One of the main differences in the incorporation process is that in Alberta, you will file articles of incorporation as opposed to having an incorporation agreement and notice of articles. The articles of incorporation will establish what classes of shares the company has, the minimum and maximum number of directors, and they can also contain certain rules or restrictions for the company. Fiona did mention this, but I thought it'd be worthy to mention again. One thing to keep in mind if you are incorporating in Alberta is to include a restriction on share transfers in the company's articles. Including this restriction will help ensure the company is considered what's known as a private company under securities legislation, which will be important when the company issues shares to its founders or to investors. Sometimes when individuals are incorporating these companies on their own, they forget to add this restriction into the articles. So worthy to bring it up again. Once you've finalized the articles of incorporation, they, along with a notice of directors and a notice of address, will need to be filed with the registrar. Unlike in BC, filing in Alberta can only be done by accredited users. So you'll actually have to reach out to a law firm or attend a corporate registry to have the filings completed. Once the articles of incorporation have been filed, your company will be created and you'll receive a certificate of incorporation. After that, you'll continue to pass various directors' resolutions and shareholder resolutions to complete certain organizational matters for the company, such as adopting bylaws. Some companies come up with specific banking bylaws and doing other initial share issuances and the appointment of, of officers like your CEO, your chief technology officer, et cetera. So with that, I will pass it on to Colin, who's going to talk briefly about incorporating in Ontario.
Yeah, thanks very much, everyone. So similar to what Jeff said, the process in Ontario is, it follows the same lines as in BC and Alberta. So I'll just try to highlight the differences. Our provincial act is the Business Corporations Act Ontario, and if you follow that link that I put right there, that'll bring you to the ministry website, and they've got some fairly helpful information. Again, if you do, not that it would be recommended, but if you did want to go down the path of trying it yourself or even just learning about it, they do their best to make a difficult process a little bit intuitive. I'll leave it at that. Same process for choosing and reserving your name, same attributes, the distinctive, descriptive, and you attach a corporate designation. You can also go with the numbered company approach, of course, in Ontario. Our filing document are articles of incorporation, so in that sense, we follow the Alberta model. And in your articles, you'll include certain key details. You're going to give them your corporate name. You're going to set out the number of the directors. You're going to give them your basic share structure. If there's any restrictions on the business that you want to set out right in the articles, you can include that there. Same thing that Jeff mentioned about share transfer restrictions. You also have to provide director consent. So if you've got any third parties who are going to serve as directors, including if you're the director of your own company, then you've got to include a consent for that. The constituting documents are the core documents for the corporation. We follow the Alberta example there, and not BC. Our core documents are our articles and our bylaws. Of course, you're going to have to also make decisions like your financial year end. You're going to have to pick your officers. You're going to have to select an auditor or bypass the auditing process. Thanks very much. Next slide. Is this Fiona? Is that you? Or?
And,
Okay, so incorporating a federal company is very similar to incorporating a provincial company. So I won't go over it again. So I think the only thing I wanted to point out is that filing at the federal level consists of filing 2 forms instead of 1. Otherwise, it's very similar process. And once again, we do not encourage you to file the process yourself. But if you want to do so, you can file the application online through the online filing center, which link has been listed on the slide. So next one.
Right. Thanks very much, Fiona. So initial share classes. So this is sort of a key, in some ways, the key decision you're going to make when incorporating your company. How are you going to, what categories of equity are you going to have, and how are you going to assign and hand out that equity? And so I don't want to go into too much detail here, but I presume so most people are familiar with the basic different categories of equity. We've got common shares and we've got preferred shares. And without sort of go through a whole law school class on this, but basically your common shares are what we typically think of when we think of equity. Those have voting rights, but then are usually last to the trough when it comes to liquidation and dividend rights. They're basically plain vanilla shares, usually in sort of layman's terms what we think of when we think of equity rights. Preferred shares are a little bit different. In many ways, they sort of mirror some of the attributes that we think of when we think of debt capital. Preferred shares, they can have voting, but they typically are non-voting. But then you're going to get certain preferences on dividends. You're going to get certain preferences in the event of liquidation or wind up. And they may have all sorts of fancy features around redemption. So if the company wanted to recall those shares or retraction, things like that. So they can be a little bit more exotic. So those are your basic categories. And there's no, I should say that there's no default, there's no typical, but there may be a typical structure, but there's no necessary structure here. You're going to decide your share structure in consultation with your lawyer based on the needs of your business and sort of where you hope that business will go to down the road. So sometimes we will see founders ask for multiple classes of common shares. And this may be, for example, if you want to offer different dividends down the line to different founders if they've got different roles. So you may have a Class A common, a Class B common, a Class C common, and that would allow you to sort of tweak the rights and entitlements of each of those classes of shares depending on the roles of the founders. And that's just an example. There could be a number of reasons why you'd want to introduce multiple common shares. You may have one set of common shares without voting rights, and you could hand those out to people sort of if they were consultants or a sort of as-needed basis. So that's generally speaking what you're looking at in common shares. Preferred shares, again, these are sort of the more exotic cousin of share. We typically, or I guess we often would see preferred shares that are issuable in series. So you've got, it could just be 1 or 2, but it could even be 3, 4, 5, or 6 series. And each of those series, we typically label them Series A, Series B, Series C, so on and so forth. And each of those series would have different rights or entitlements, and that would be different rights and entitlements in terms of dividends, what sort of dividend or what level of dividends they get in the event of liquidation or wind up of the corporation, where they rank in terms of preference, sort of who gets the first crack at whatever's left over if the corporation were to wind up, and then all sorts of redemption features. Or retraction features like that. And preferred share features can be really, really detailed. Just the term setting out the rights and entitlements can go on for pages and pages. And you may want to issue them in series because you may want to make allowances maybe for different rounds of investors or to attract different investors with different terms. I'll just touch on this last one briefly, but we've got blank check preferred shares. And these are attractive sometimes for founders because what essentially they set out are base sort of minimum or standard terms at incorporation. And who knows, what's going to happen to the business or what sort of interest it's going to have going forward. And you want that flexibility in terms of maybe attracting investors of a different type. So basically what they do is you set these base terms, and then you say beyond that, the directors are gonna decide, and they're gonna pick, when the time comes to issue those shares, they're gonna set out exactly what the features are. Thanks very much. Next slide.
Thanks very much. That was great. And thank you. Perfect. Okay, so we'll switch to founder shares. I'll just add a couple points on common shares versus preferred shares. Just at a high level, just to give an example of why you might want a preferred share to exist, and this is kind of how they historically came into existence, is let's say Colin sets up a business, he incorporates it himself, he's the sole officer, and he wants me to invest, and I'm going to put $1 million into Colin's, no doubt, excellent business. So I invest $1 million, and Colin goes, says, bad news, Mike, the business just went bankrupt 2 minutes after you made your investment. And now, if we're both common shareholders, one of the rights that Colin mentioned was that we have, in addition to voting rights to dividends, we have rights to assets on liquidation. And we divide those up now between me and Colin. And I said, well, that was all my money. So as an investor, I might want a preferential right to liquidation on assets. So I'll give you $1 million, but tell you what I get, if you go bankrupt, all the money comes to me first, and then whatever's left over can come to other common shareholders. So that's an example of a preferred share right. And of course, once lawyers got involved, we got now preferred share, once we set that template of preferred share rights for certain investors, they can be pages and pages and pages long. But as a founder, what you want to recognize is they are advantageous to the preferred shareholder over you, the common shareholder, the founder. So our recommendation is to keep it simple for as long as possible. So with founders, we recommend you issue yourselves common shares, which are simple. You each have rights to vote. You have rights to dividends, equivalent rights to dividends, and equivalent rights to liquidation of assets in a bankruptcy scenario. And stick with a simple capitalization table as long as possible. And that would include your friends and family round, your angel investors. Keep simple as long as possible in terms of keeping common shares. Sophisticated venture capital investors will want preferred share rights associated with their investment. Their investors will demand it. And that's when you tend to see things, so the first venture capital round is typically your first round of preferred shares, which is what's commonly known as your Series A financing. And then additional rounds of venture capital financing would be your Series B, Series C. Those are different rounds or different classes of preferred shares, just to sort of explain that nomenclature. But again, our recommendation is to keep it simple as long as possible by just issuing common shares. Okay, so just a couple other notes on founder shares. When you're issuing your initial founder shares, you're issuing shares in exchange for typically one of three things. You're issuing shares in exchange for money, so I'm putting money in the business. You're issuing shares in exchange for intellectual property. Someone's got a really good idea they're giving to the business. Or you're issuing shares in exchange for contribution in terms of your own efforts. And when I'll touch on share vesting, which touches to the last. So if you just give money to a company as an investor, you'll get shares without any vesting. If you're a founder and you're issuing IP, that will go to your initial investment. And if you're expected to contribute a certain amount to the business, that will sort of go to the amount. So as founders, you'll think about each of your relative contributions to the business on those three terms, and then you'll figure out, you'll have a, at times, difficult conversation about who gets what. So perhaps if it's someone's idea, maybe they get 60% of the common shares, and someone who doesn't have the idea but will be contributing to the implementation of the business plan might get some lesser amount, and it could be divided up among shareholders. And perhaps someone who's contributing some money would get an amount on top of that. So you'll have to sit down and have a conversation among the founders about how many, what proportion of the business you each get. Lawyers can help guide that discussion, but ultimately it's a business decision among the founders. So that's sort of the first point. How many shares should we each get? important to have that discussion early on in the business. So important to have that. Some people want to sort of delay that conversation because it can be difficult. We encourage founders to have that conversation as early as possible to make sure everyone is on the same term. It can lead to a lot of acrimony and a lot of conflict if you start a business, you start contributing money, IP, effort, and you're not on the same page of who owns what. So we encourage business owners and founders to have that conversation as early on as possible. Okay, so now share vesting. What does this mean? So if you're contributing money, you just get your shares outright. If you're contributing IP, you get your shares outright. What if you're getting shares under the expectation that you're going to play an officer role and contribute, let's say, 20 hours a week to the business for the next 4 years, and you leave the next day? It would seem unfair for you to get all your shares on founding and not have them sort of taken back if you simply leave the company. So share vesting is essentially, it's a bit of a misnomer. What share vesting does is it gives the corporation a repurchase right. And it gives the corporation the ability to repurchase shares at cost, which for a new business is a nominal amount, sort of pennies per share or less. So if, again, using my business with Colin, takes me on as to be a chief financial officer of his business, a foolish decision, but nonetheless, and he says, you'll get 1 million shares for your efforts, but I expect you to play this role for 4 years, and I leave immediately. The business would have the right to repurchase all of my shares at cost. But a vesting schedule would say that those would vest, let's say, 1 quarter every 4 years. So if I leave after 1.5 years, he would only be able to repurchase 3/4 of the shares that were initially issued to me. The idea at that point is I've earned 1/4 of my shares by living up to my 1/4 of my bargain, but the company has the right to repurchase those. So that can be a pretty useful tool for founders to consider at the outset, especially if there's a mismatch, if someone's putting in the IP and someone else is simply expected to contribute to the business through their efforts. That's a situation where you'd likely want to consider share vesting, and that can be built into the founder shareholders agreement, which we'll talk to in a moment. Okay, next slide, please. And in a moment, I mean right now. So founder shareholders agreements, I'll talk very briefly about why you want a shareholders agreement as common shareholders. And people don't necessarily want to think of this right out of the gate, but we think it's important that founders do. If there's more than one of you, if there's only one of you, you don't need a shareholders agreement. Shareholders agreement is a contractual agreement among the founding shareholders, typically initially on incorporation of the business. Now, the issue it primarily seeks to address is under corporate law. If you have 50% plus one of the voting rights associated with a business, you can call a meeting. You can then propose directors. Let's say I own 50% plus one of the shares of a business. I call a meeting. I propose a director. I suggest myself. I now have the ability to vote all my shares in favor of myself. I'm now the director, sole director. As a sole director, I can appoint officers. I choose, once again, myself. And now as CEO, I run the business. And the person holding 49% of the shares essentially has no day-to-day operational control of the business. Most business founders would consider this completely unfair. So what a shareholders agreement designs to do is it supplements the obligations under corporate law by saying we contractually agree to vote our shares together in a certain way. And this can cover a whole host of matters. And with that, I'll turn it over to Fiona to talk about some of the items that are typically addressed in a shareholders agreement.
So here's some key terms that in the founder shareholders agreement. The first one is the board composition and officers. Usually in the shareholders agreement, we're going to set up the number, excuse me. So we're going to set up the numbers of directors, details of directors' meetings, such as the frequency, the quorum of the meetings. Those things are going to agree in the founders shareholders agreement. And sometimes the officers will be appointed and agreed on as well in the shareholders agreement. to ensure that the shareholders are fairly represented in the daily management of the company. The second is the key matters that require consent of founders. Usually those are significant corporate matters. For example, this may include any material change in the business of the company, the sale of any assets of the company, any change of the company's articles or bylaws. And in the agreement, it's also very common to spell out the percentage of founder shareholders that needs to prove such matters. And there are also some key terms dealing with the shares of the company. For example, usually in a founder's shareholders agreement, there is a restriction on the share of transfers. The shareholders agreement may state that the share transfer is restricted or prohibited, subject to the right of first offer or the right of first refusal or the consent of other shareholders. And I'm going to hand back to Mike to speak more about other shareholders' rights related to the shares.
Great, thanks, Fiona. There's one other key right I wanted to highlight, which are the drag-along and tag-along rights. So the drag-along right is critically important if you're the majority holder. So let's say I have 60% of the shares of the business. I've now contractually agreed with my fellow founders to as to who we're going to appoint as directors and how we're going to vote our shares in terms of director appointments, officer appointments. We've agreed on sort of how we're going to run the business and key matters that might require the consent of all of us as founders, so I can't simply run the show. But if I want to sell, or if a significant majority of the shareholders want to sell the business, we want the ability to compel minority shareholders to sell. So let's say, and the threshold can vary, but for example, you might say if 80% of the shareholders agree want to sell the business, we need to be able to compel the minority shareholders, the other 20%, to sell on the exact same economic terms. That can be important because you can imagine if you have a 5% shareholder sitting there, and a big business wants to come along and buy my incredibly successful medium-sized business for an extraordinary amount of money and a premium that I find very attractive, and I want to sell, ready for me to move on. The 5% shareholder can sit back and say, that's not enough for me to sell, I'm going to ask for more, and essentially gives that minority shareholder a veto right in the absence of a shareholders agreement. So from the outset, critically important to have a shareholders agreement so that a minority shareholder is not in a veto position should you want to capitalize on your efforts in sort of creating value in your business when it comes time to one of the most common exit opportunities, which is selling the business. So critically important and really difficult to negotiate further down the road. So important to get that set up in place. There's a couple other, I won't go through these in detail. As I mentioned, share vesting can be built into the shareholders agreement, and it deals with a number of these other matters as well too. I will highlight that our StartUp&Grow legal package does include a robust shareholders agreement that I think works very well. So something we'd be able to talk a bit more about, should that be of interest. Now, I wanted to talk about one jurisdictional point. In BC, it's not uncommon to have multiple shareholders agreements. So you'd have one shareholders agreement for your founders, and then you might have a separate shareholders agreement for all your new investors. You might even then have a separate shareholders agreement for consultants and advisors. So the founders and the company would be party to all those and would have the rights under all those agreements, but you might have different agreements for different groups of people. So for example, the founders in the point 2 that Fiona mentioned, and key matters requiring consent. So the founders might have voting rights in terms of key decisions. Are we going to sell the business? Are we going to take on debt? Are we going to issue a dividend? Or things like that. We don't want to give, as founders, we don't want to give those rights to investors or advisors or consultants, so we give them a much skinnier shareholders agreement. Now, it's done a little bit differently, so I'll turn it over to Jeff, and I'll start with Jeff and then Colin to talk about how they set up shareholders agreements in Alberta and Ontario.
Sure, thanks, Mike. So in Alberta, the shareholder agreement concept is actually recognized and built into the corporate statute. And so as a result, we have what's known as unanimous shareholder agreements, or USAs, as opposed to founder shareholder agreements or multiple shareholder agreements with different shareholder groups. The USAs cover the same matter, the subject matter, as the founder shareholder agreements, but here you really just have one agreement that all the shareholders are a party to. And you can still grant different rights to different groups of shareholders under that USA, but that's just done through the drafting, and particularly the use of certain defined terms, as opposed to having standalone separate agreements. I will note that one of the main advantages of having the USA concept, which exists in Alberta, and I believe in Ontario as well, which Colin will speak to, is that if the USA is properly drafted, all new shareholders of the corporation will be deemed to be parties to these agreements, which is a nice have, and it provides some certainty that the agreement is going to have the desired effect, and you don't need to negotiate a new agreement with new shareholders every time. But I'll pass it off to Colin to talk a little bit about Ontario.
Yeah, thanks very much, Jeff and Mike. The concept in Ontario is identical, essentially, to, or for all practical purposes, to Alberta. So we've got one document for all the shareholders of the corporation. And just as Jeff said, the way we assign different rights to different shareholders is just through the use of defined terms, different sections, different rights for different sort of categories or levels of shareholders. So you'll even see things. In fact, it's quite common to see things like, if you're a shareholder over X percentage, then you are entitled to the right set out in this section. And if you're not, if you're sub that percentage, then you are entitled to the right set out in this section. So it'll be divided sort of operatively like that, just based on the level or the extent of your shareholding, for sure. Thanks. Back to Mike.
Great. Thanks very much, Colin. And we'll move on to the next slide. So that's primary, two key takeaways there is think about a shareholders agreement earlier rather than later. Very challenging to implement one down the road. And the shareholders agreement is an opportunity for the founders to put down in writing their understanding about how the business is run and make sure you're all on the same page at the outset. Again, can save an awful lot of acrimony down the road. And we've seen, I think each of us have seen sort of unfortunate results when there are disparate expectations that surface down the road for new businesses. So certainly something we encourage business owners to think about at the outset. And also just the nomenclature point, you'll hear the term unanimous shareholders agreement used in Ontario and Alberta and not in BC, and that's just to explain why that's the case. It doesn't exist under corporate law in BC. Okay, just a quick, before we turn to questions, some other key considerations you'll want to think about is making sure you have appropriately documented employment agreements with your founders and your employees that will cover off intellectual property and some other important obligations such as confidentiality. Similar with your contractor agreements, again, critically important to protect the intellectual property prepared by contractors. You'll probably then be thinking about financing. Stay tuned, we'll have a Startup and Grow webinar on financing considerations. Want to make sure you've got a plan to protect your intellectual property. As I mentioned, our second webinar, which is available on our website, goes into some detail about how you might want to protect your intellectual property, so I encourage you to check that out. And then making sure you have a well-documented plan in terms of how to commercialize your business plan, which can involve typically a discussion of an appropriate licensing arrangement for early-stage technology companies. And again, some of these matters are dealt with in our legal package, some are not, and any of us would be delighted to talk with you a little bit more about any of these items. Okay, on to the next slide, which I think turns us to questions. Okay, we've got about 4 minutes left here, so I will just randomly pepper people with questions. I'll take the first one, which is, we had a question, what is an LLC and how does it differ from an Inc.? So an LLC is a limited liability corporation. It's a U.S. concept. It doesn't exist in Canada. So oftentimes you'll see American entities set up as LLCs. There's tax reasons, which I'm not going to attempt to explain, why a U.S. business might want to set up as an LLC. So just know it doesn't exist in Canada. In terms of a corporate designation, you can be a corp, you can be an LTD, you can be an Inc., seems to be the most fashionable, you can be limited, you can be incorporated, but you tend not to see LLC in Canada. So thank you very much for that question. Since we've got a smart tax lawyer on the presentation today, maybe I'll give the next one to Danielle. For a new business owner, I want to take money out of my business. I'm looking for a tax-effective way to get money out of my new business, and the question is it better to draw a salary from my business as an employee, or to take dividends, or is there some other alternative?
Thanks, Mike. So we generally recommend that an employee an owner-manager takes a salary up to sort of the amount of money that you need to live, and also the amount of money that you could contribute personally to a TFSA or RRSP, because those are sort of tax advantageous investment vehicles for you. And you can only invest, at least on the RRSP side, you can only invest to the extent that you earn salary. If you take dividends, that doesn't affect your RRSP room. After that, then, whether you take dividends or whether you take salary, it'll depend on how many shareholders you have. Do you have to pay dividends to those other people? Kind of on a basic level on the tax side, the salary is deductible to the corporation, the dividend is not. And so you just have to look at the math and look at the rates and decide what's best for you in your situation.
Great, thanks, Danielle. So the first question came from Peter, and that last one was from Supriya. Thank you very much, both of you, for your questions. I will take just one more question, one that's submitted via our Q&A function, coming from Akshay. Are there any preferred structures for a combination of residents and non-resident shareholders? This is sounding like another question for Danielle. Or for an external company setting up an operation in Canada in partnership with a resident. Danielle, any thoughts?
Yeah, that's a difficult question to answer generally. It will depend on what country your non-residents are coming from, and whether you're looking at a majority voting interest to be resident or non-resident. As I talked about in my tax portion, there are lots of tax benefits to being Canadian controlled, and so to the extent that you can organize the affairs so that your company remains a CCPC, that's usually advantageous. But the specifics of your particular situation, how much money the non-resident is investing, how much money you're investing, kind of what role everyone's playing will determine what the particular structure is. There's no set structure that is always best when you have a mix of residents and non-residents. Thanks
very much. And if you have additional questions, I highly recommend Danielle as a resource for these types of questions. Many of us make use of it for these types of questions as well. So thank you very much for that question. So with that, I know we're at time. So I'll just plug our next session coming up. So the Startup and Grow webinar series will be held on the second Wednesday of each month, always at the same time. Our next session will be on hiring practices and key employment law considerations. So it'll be it'll be sort of half and half between employment law considerations, and we'll have an external consultant working in the area of hiring and recruitment for startup and early stage technology businesses. So it'll be sort of, unlike this session, it'll be a bit of a half and half mix between some practical business considerations and some legal considerations when thinking about adding new employees to your business. So stay tuned for that. We certainly hope you can join. And on to the next slide, please. If you have questions for any of us, we'd be delighted to talk to you a little bit more. We're happy to have sort of initial calls sort of off the clock. If you have questions for us, we understand that that's important, particularly for startup and early stage businesses. So if you do have questions, you can find our contact information here. Please feel free to reach out to us by email to set up a time, or by phone. We'd be delighted to talk with you and share a little bit more if you have questions on any of the topics we covered today, or on any other elements related to your new business. And with that, I'll say thank you very much to our panel of presenters today. Colin, Danielle, Fiona, Jeff, thanks very much. I thought that was excellent. And thank you to our guests. Thanks very much for taking the time to join us today. We appreciate it. Delighted you could join, and we hope to see you at a future session. Thank you very much, and we'll see you next time.